Style constant applied. The elevator stopped between the 7th and 9th floors at 9:02 a.m. Cause no. D1 DC 2301847 was on the 9th floor docket that morning. I knew Rule 5. I took the south elevator anyway. 31 minutes I stood in that car, phone signal gone, briefcase on the floor, listening to the ventilation cycle on and off. By the time the doors opened, the docket call had already happened. By the time I reached the courtroom, the clerk had already noted my client's absence. By the time I found a phone to call the office, there was a bench warrant with my client's name on it. That's Rule 5. And today, someone just broke it. Harris Caldwell gave me 5 rules on my first day. That was 1997. He wrote them on a single index card, cream-colored, the kind with blue lines, the kind you buy in a 10-pack at any office supply store. He wrote them in block letters with a ballpoint pen and held the card across the desk without looking at me. I was 26 years old. I had passed the bar 3 months earlier. I thought it was a joke. I kept the card in the back of my desk drawer for 6 years before I started actually reading it. Harris Caldwell retired from criminal defense in 1994. 31 years of practice. He had argued before the Texas Court of Criminal Appeals 16 times. He had won 11. The day he handed me the card, he was packing the last of his files into a banker's box, and the office smelled like old paper and coffee grounds, and he said, "These kept me whole." He didn't say they kept him winning. He said they kept him whole. I should have asked what the difference was. Instead, I thanked him, put the card in my pocket, and spent the next 6 years believing I was smarter than a handwritten index card from a man who had been practicing law since before I started grade school. I look back on that version of myself, and I don't feel superior to it. I just feel sorry for it. Rule 1 is written at the top. It takes up 2 lines. Never file any pleading between 4:47 p.m. and 5 p.m. on a Friday. Not even a notice. Not even a proof of service. The first time I read it carefully was 2003. I was a second-year associate, working late on a Thursday. And I found the card in my drawer while looking for a pen, and I read Rule 1 and thought, what kind of neurosis produces a rule that's specific? 4:47 p.m. Not 4:45. Not 5, 4:47. Rule 1, the filing window. There's a case in the firm's closed files called State v. Tremaine Boggs, cause number CR 91-4812F, Travis County, capital murder. Caldwell tried it alone, no second chair, in the fall of 1991. His client was convicted, sentenced to death. Caldwell filed every appeal himself. Every motion for stay, every writ of habeas corpus. The last motion he filed for Boggs was a motion for continuance of the execution date, pending a newly discovered affidavit from a recanting witness. He filed it on a Friday. The clerk's stamp on the motion reads, "Received 4:52 p.m." That is on page 7 of the court docket printout. I know the page number because I pulled the file myself in 2006, when I finally understood that the rules on Caldwell's card were not rules he had invented out of habit. They were rules he had extracted from catastrophes, one catastrophe at a time. The judge's docket shows no record of receipt until Tuesday morning. Tuesday morning. The execution was Monday, the death warrant had been signed Saturday, somewhere between the clerk's receiving desk on Friday at 4:52 p.m. and the judge's docket on Tuesday morning. 72 hours passed. The motion sat. The execution didn't. I don't know if Caldwell slept that weekend. I know he filed a grievance. Bar complaint number TX 1994-2219. The grievance was resolved without finding. That is the language they use. Resolved without finding. It means something happened and no one was found responsible, and the outcome stands. Caldwell retired 4 months later. He wrote the rule on an index card and handed it to the next attorney who was going to sit in that office. He wrote it, "Never file any pleading between 4:47 p.m. and 5 p.m. on a Friday." The Boggs motion was filed at 4:52. The 5-minute window. That's where the rule comes from. That's where every rule on that card comes from. A specific case, a specific minute, a specific consequence that Caldwell witnessed and could not explain and could not fix and could not let happen again. He couldn't unfile the motion. He couldn't reopen the docket. He couldn't give Tremaine Boggs back what that 13-minute gap between 4:47 and 5:4 cost him. So he wrote a rule, and then he wrote 4 more. I started keeping the card in my breast pocket instead of my desk drawer in 2006. Same year I pulled the Boggs file. I didn't tell anyone why. You don't tell people you've started carrying an index card because a retired attorney's handwriting is starting to seem less like neurosis and more like a record of events that someone needed to survive. Rule 2 is about judges. Keep a handwritten list, not typed, handwritten, of every judge who has ruled against you on a suppression motion. Never waive a jury trial before any name on that list. Caldwell had a list. I found it when I was going through the closed files, a separate sheet folded inside the Boggs folder, which is where he apparently kept everything that mattered. 14 names, 14 judges who had ruled against him on suppression over 31 years. Not 14 names he disliked. Not 14 names he found difficult. 14 names attached to specific rulings where the suppression denial was the turning point in the case. One of the names on the list is Judge Anita Reyes. Rule 2, the recusal list. There's a case in the same firm archive called State v. Darnell Pruitt. Cause number CR079341C. That case was handled by a different attorney, one of Caldwell's other associates, a man who left the firm in 2009 and now does real estate closings in New Braunfels. He tried the Pruitt case before Judge Anita Reyes. He waived a jury. He did not have Caldwell's list because Caldwell's list was in the Boggs file, which was in a banker's box in a storage unit in North Austin labeled Closed Matters pre-1995. Bench trial. Conviction. Pruitt got 22 years. In 2018, Judge Reyes's courtroom clerk, a man named Albert Voss, pleaded guilty to falsifying bench trial transcripts in 14 cases over 11 years. 14. The number was in the plea agreement, Exhibit C, page 2. He listed the cause numbers. State v. Darnell Pruitt, cause number CR79341C, was case 11 of 14. The transcript, Voss admitted, had been partially retyped. Page 44, the cross-examination of the arresting officer had been altered to remove 3 questions and 2 answers that would have supported the defense's suppression argument. Pruitt had been in Huntsville for 11 years by then. The case went back for review. I don't know the current status. I know that Caldwell's list had Reyes's name on it. I know the rule says never waive a jury trial before any name on that list. The associate who handled Pruitt's case didn't have the list. He had no way to know. That is the thing that stays with me. Not the corruption. That happens and it gets discovered and sometimes it gets corrected. What stays with me is this. The information that could have changed the outcome of State v. Darnell Pruitt existed. It was on a piece of paper in a storage box 14 miles from the courthouse. It just wasn't in the right hands. Caldwell couldn't know that Reyes would be assigned to a case his successor would try. But he wrote the rule anyway. He wrote it as if the future would find a reason for it. And the future did. I don't have a conclusion to offer about Rules 1 and 2 beyond what the documents show. Rule 1 comes from a motion filed at 4:52 p.m. on a Friday and a man who died on Monday. Rule 2 comes from a list that existed in a banker's box and a bench trial that should never have been waived. Those are facts. Caldwell was meticulous. He wrote things down because he had learned, once, the hard way, what happens when a thing exists only in memory. Style constant. Rule 3 is the one that made me move my office. Not permanently, just whenever a file came back in a red folder. If a client's physical file has been rejacketed in a red folder, meaning someone replaced the original manila, do not speak in your own office. Take the file to the parking garage. The first time I read that rule in full, I laughed. I read it standing in my office on a Tuesday afternoon in 2009, and I laughed out loud and folded the card back up and put it in my pocket. A parking garage. I pictured Caldwell, gray-haired in his 60s, carrying a case file through a parking structure, whispering strategy into a concrete column. It seemed like the kind of story people tell about attorneys who worked too long and burned too bright and ended up seeing patterns in things that were just administrative errors and coincidence. I told myself that if I ever found myself in a parking garage with a case file, I would know it was time to retire. I have been in that parking garage 17 times. Cause number CR 22-00318D, drug distribution case. 8 counts. Ashworth had a prior, a single possession charge from 2015, deferred adjudication, completed without incident. The prosecution was offering 36 months, which given the prior and the count volume was arguably reasonable. I thought we could get to 24. And I thought that because I had a suppression argument, that if it worked, would exclude the primary evidence. A vehicle search conducted with a warrant that had a material misstatement in the affidavit. I had not written that argument down. Not in the file, not in my notes, not in any correspondence with co-counsel, because I didn't have co-counsel on this case. I worked it through in my head, standing in my office on a Thursday afternoon, file open on my desk. The file was in a red folder. I noticed the red folder. I registered it. And then I kept talking, not to anyone, just processing out loud the way you do in an empty office when you're working through the bones of an argument and you need to hear it in the air before you write it down. The way you do when you think you're alone and the walls are just walls. The prosecution filed a plea offer the next morning. Date stamped 8:14 a.m. I read it at 8:52 when I arrived at my desk. 3 items in that offer corresponded exactly to positions I had taken in my head the afternoon before. The suppression angle, referenced indirectly, worded as given the potential evidentiary challenges, but referenced. The revised charge structure, not what they had been pushing for 6 weeks, and a restitution figure. $47,500. $47,500. I had never written that number in any document. I had never said it out loud to another person. I had arrived at it by mental arithmetic, standing in my office, calculating the gap between Ashworth's assets and the prosecution's original demand, arriving at a number I thought represented a workable split. I know the approximate time I arrived at it because I checked my phone immediately after, the way you do when something clicks. 3:41 p.m. The prosecution's letter, date stamped 8/14 the following morning, contained $47,500. I sat with that for 3 days. I went through other explanations. Maybe they had run similar arithmetic. Maybe they had independently landed on the same figure. Maybe it was coincidence. 2 parties calculating toward a midpoint and arriving at the same number. I almost convinced myself. And then I went back and looked at the file folder. Red, not manila. Red. Our firm uses manila for everything. We have used nothing but manila since I joined the firm in 1997. The supply room cabinet holds boxes of 100 at a time. I went to the supply room. Every folder in the cabinet was manila. I went back to my desk and looked at the Ashworth file. Read. I don't know where it came from. I don't know who touched the file between the day it was opened and the day it appeared in that color on my desk. I know that I spoke out loud in that office, alone, with a red-jacketed file on my desk. I know that the prosecution knew things the next morning that I had not written down. After that, I started taking files to the parking garage. Not every file, only the ones in red folders. In 3 years, I have had 4 red files. I have stood between concrete columns with all 4 of them. I am not embarrassed about this. Rule 4. The courthouse clock Rule 4 requires more context to understand, because it requires believing that Harris Caldwell spent 22 years taking notes on a courthouse clock. If the main lobby clock in the Travis County Civil Courts building is running more than 90 seconds fast, do not enter a plea that day. Reschedule. The notepad is in the same storage box as the Boggs file. 22 pages. Each page covers roughly 1 month of court days. Each entry has the date, the time Caldwell checked the clock, and the number of seconds it was running fast or slow relative to his watch. He checked his watch against the courthouse's own time of day phone service before each entry. He was systematic. Most entries read +012 or 24 or +008. Small variances. Normal clock drift for a mechanical movement. 11 entries across the 22 years show a reading over 60 seconds. 4 of those entries are annotated. The annotations are brief. Caldwell was not a man who used more words than the situation required. October 14th, 1987, +112 do not enter today. March 3rd, 1992, +145, rescheduled all appearances. November 19th, 1996, 208, stayed home. And the last annotated entry from the week he retired in 1994, 158, final entry, the rule holds. I thought about that notepad for a long time before I understood what it was. It was not superstition, it was a log. Caldwell had noticed, over 22 years of practice, that on days when the lobby clock ran fast by more than 90 seconds, something went wrong in the paperwork. Not a mystical wrongness, a procedural one, a filing that didn't register, a docket entry that appeared a day late, a plea that ended up on the wrong case jacket in the clerk's system. Not always dramatically, but consistently enough that he started writing it down, and then rescheduling on the high drift days, and then writing a rule. State vs. Ramon Castillo, cause number CR 19-7741A. I checked the lobby clock that morning. It was running 1 minute and 58 seconds fast. I noted it. I stood in the lobby and I held the card in my hand and I read Rule 4. And then I put the card in my pocket and walked into the building anyway. Castillo had been waiting for his arraignment for 3 weeks, and I did not want to reschedule and look like I was stalling. I entered the not guilty plea. The clerk noted it. We left. 3 weeks later, I received a letter from the Travis County District Clerk's office. The letter referenced an audit memo, case ID error log, entry number CR-19-7741A. Due to a data migration issue on the date of the hearing, the entire docket for Courtroom 6 had been logged under an incorrect cause number prefix in the new electronic filing system. Castillo's not guilty plea was not present in the electronic record, administratively absent. The prosecution filed a motion arguing that arraignment had never properly occurred, that there was no record of the plea, and that proceedings should not advance. We had to rearraign. We spent 11 days in procedural limbo while a clerk's data entry error on a specific day in a specific courtroom, the day I ignored the rule, undid a 30-minute hearing. I went back to the notepad, the last annotated entry, 1994, +150 final entry. The rule holds. The morning I entered Castillo's plea, my lobby clock reading was 1 minute and 58 seconds fast. Same number, same courthouse, different decade. I do not know what that means. I know it means something. I have not entered a plea on a high drift day since. Rules 1 through 4 I can trace to cases, to documents, to docket numbers. Rule 5 is different. Caldwell never annotated it. There is no case file in the storage unit that explains it. There is only the rule, in block letters, at the bottom of the card. Never ride the south elevator to the 9th floor on any day a capital case is on that floor's docket. Take the stairs or the north elevator. And one line Caldwell said the morning he handed me the card, a line I didn't fully hear at the time. The people who have ignored this are not practicing anymore. I heard it as a figure of speech. They retired, they moved to another city, they changed careers. That is what I thought not practicing anymore meant. I no longer think that is what he meant. Style constant applied. Cause Nober, D1 DC 23001847. Capital murder. Travis County. My client's name is not relevant to what happened, but the docket number is, because it's the reason I ended up on the south elevator on a Tuesday morning in March 2023. I was running late. Not badly. 7 minutes. The north elevator lobby has a longer walk from the parking entrance. I made a choice. I told myself the rule was for another era. I told myself Caldwell had practiced in a courthouse where things worked differently. I told myself 7 minutes is 7 minutes, and the judge on this case does not wait for anyone. I took the south elevator. The car stalled between the 7th and 9th floors at 9:02 a.m. I know the time because my phone showed it when the doors closed, and by the time the car stopped, I had already watched the number change from 9:01. There was one other person in the elevator, a court security officer named Vasquez, according to her badge, who immediately picked up the internal emergency phone and reported the stall. We stood there. The ventilation fans cycled on and off. My briefcase was on the floor because I had set it down to check my phone for signal. No signal. 9:06, 9:15, 9:33. The doors opened. 31 minutes. I got to the 9th floor at 9:37. The docket call for cause number D1 DC-23-001847 had been at 9:03. I know that because the courtroom's electronic timestamp, the one on the court reporter's log, read 9:03 a.m. for the case call. My client had been present, his presence was noted, my absence was noted. The judge had issued a reprimand and continued to the next case. No bench warrant. He used discretion because my client was present and represented the situation to the court. But the record shows counsel non-appearance. The record shows I was not in the room at 9:03. I went to the clerk station immediately, I explained. I showed the elevator maintenance log, which I obtained from the building engineer on the same day, because I was not going to leave that building without paper. The maintenance log shows south elevator, stall event initiated 9:02 a.m., doors restored 9:33 a.m. The clerk looked at the log. She looked at the courtroom timestamp, 9:03 a.m. She said, the docket was called at 8:57. I looked at the court reporter's digital log. It said 9:03. The clerk said the court reporter's system had a lag. She said the actual call, the live call in the room, was 8:57 a.m. She said the judge had waited 6 minutes before the digital timestamp captured the entry. I said, then the digital entry at 9:03 is wrong. She said, the timestamp reflects when the entry was typed, not when the call occurred. I said, then the case was called 6 minutes before my elevator stalled. She said, yes. I looked at the maintenance log again. South elevator, stall event, 9:02 a.m. If the docket was called at 8:57, 6 minutes before 9:03, and the elevator stalled at 9:02, 5 minutes after 8:57. Then I was already late before I got into the elevator. I was already late. The elevator didn't make me late. I was late before the elevator stalled. That is the factual reading. That is the reading that makes sense. Except I wasn't late. I was in the parking garage at 8:49 a.m. I have the parking garage timestamp ticket. I was at the ground floor elevator bank at 8:54. The south elevator lobby is 90 seconds from the parking entrance at a normal walk. 8:54 arrival at elevator. 8:57 claimed docket call. 3 minutes to travel from elevator lobby to courtroom, possible if the elevator came immediately and I walked fast. Not impossible. But the elevator maintenance log shows the car left the ground floor, its last recorded departure before the stall, at 9 a.m. 9 a.m. ground floor departure. If I boarded at 8:54, where was I for 6 minutes? I went back to Officer Vasquez. She had also noted the entry time in her shift log. 8:58, passenger board, south elevator, heading to floor 9. 8:58, not 8:54. She wrote 8:58. That matches a 9 a.m. departure. But my parking ticket shows 8:49 arrival. From parking to elevator lobby is 90 seconds. I don't know where the 8 minutes went. I don't know what I was doing between 8:50 and 8:58. I don't remember a gap. I remember walking from the car. I remember checking my phone. I remember the elevator lobby. 8 minutes are not in my memory. The elevator was stuck from 9:02 to 9:33. The docket was called, depending on which record you trust, at either 8:57 or 9:03. I don't know how to make all of those facts live in the same universe. I have tried. I went back to Caldwell's index card that night. I read Rule 5 again. Never ride the south elevator to the 9th floor on any day a capital case is on that floor's docket. Take the stairs or the north elevator. No annotation, no case number, no bar complaint reference, nothing, just the rule. I went to the storage unit the following weekend. I went through every box. I found the notepad. I found the Boggs file. I found Caldwell's recusal list. I found one more thing I had not noticed before. At the bottom of the Boggs box, under a stack of exhibit copies, there was a single photograph, black and white, courthouse exterior. On the back, in Caldwell's block letters, Star South Elevator. October 1993. This was the week Thomas Ardell stopped practicing. He didn't say why. I don't know who Thomas Ardell is. I looked up his bar number. TX 1778-0641. License status, voluntarily surrendered, November 1993. No disciplinary action. No explanation in the public record. Just surrendered. 1 month after the photograph. I still have the card. I carry it in my breast pocket. I do not take the south elevator. I check the lobby clock every morning before I enter a plea. I keep a handwritten list of judges. I don't file after 4:47 on a Friday. And when a client's file comes back in a red folder, I pick it up and I walk to the parking garage and I stand between two concrete columns and I say whatever I need to say. Caldwell said these rules kept him whole. I think I understand now what he meant by that. He didn't mean they kept him sane. He meant they kept him standing. 31 years of practice. I'm in year 26. I still have 5 years before I have to decide what I write on the card I hand to whoever sits at my desk next. Last week I drove past the storage unit and I thought about going in, about checking the Boggs box again, about looking at the clock notepad one more time. I didn't go in. Some records you read once and carry, some you don't read twice. Style constant applied. I thought for a long time about whether to write any of this down. The problem is that everything I've described is documented. The elevator maintenance log is in my file. The parking ticket stub is in my file. The officer's shift log entry, 8:58, passenger board, south elevator, is in my file. The court reporter's timestamp reading 9:03 and the clerk's insistence on 8:57 are both in my file. Cause no or CR 91-482F. Cause no. CR 079341C, cause no. CR 2200318D, cause CR 197741A, cause no. D1DC 23001847. 5 docket numbers. 5 rules. 5 times something happened that the paperwork cannot cleanly explain. I'm not asking you to believe in anything that lives outside the record. I am asking you to consider what it means when a retired attorney in 1994 writes 5 rules on an index card, and every single one of those rules turns out to correspond to a documented procedural anomaly that his successors encounter over the next 3 decades. Either Caldwell understood something about how this courthouse functions that no procedure manual has ever codified, or the rules are noise and the anomalies are coincidence. I have 26 years of practice. I know what coincidence looks like. I carry the card in my breast pocket, and I don't take the south elevator.